What if I told you that every bill you get in the mail, every notice from the court, even your mortgage, isn't what you think it is? Today, we're jumping headfirst into a really fascinating perspective from our source material. It suggests our entire legal and financial world is actually built on a hidden layer of contracts we never realized we were signing. Let's decode it.
All right, so here's our roadmap for today. First, we'll tackle the main idea, that the system isn't what it seems and everything is a contract. Then we'll see how that idea gets applied to something huge, like a mortgage. After that, we'll step into the courtroom. From there, we'll look at the supposed power hidden in everyday paperwork. And finally, we'll get into the wild idea that legal words themselves are weapons.
Okay, let's kick things off with the foundational concept. According to our sources, the system we all deal with every single day, well, it's not what it appears to be. The core argument is that it's a world built entirely on contracts. And the kicker? We're supposedly signing them all the time without even knowing it.
This quote from one of our sources really gets to the heart of it. Think about that for a second. The argument is that every bill, every ticket, every official-looking notice, it's not an order, it's not a command, it's just an offer, an invitation to enter into an agreement that you can apparently accept, or, as we're going to see, challenge.
And this brings us to a super important term from the source material, presentment. The idea here is that these aren't just offers, they're called presentments. And here's the crucial part. You supposedly have the right to challenge the authority of whoever is making that presentment. The theory is, if they can't prove they have the standing to make the offer, it's basically invalid.
So the theory gets even deeper. It suggests there are kind of two parallel legal universes operating at the same time. You've got the private jurisdiction, which runs on common law, and then you've got the public jurisdiction, which is run like a business, based on commercial contracts. The claim is that most of us, just by doing normal things like getting a driver's license, have unknowingly agreed to step out of the private world and into the public, commercial one.
Okay, so how does this contract theory actually play out in the real world? Well, let's take one of the biggest financial deals anyone ever makes, a mortgage. The sources ask a really critical question. When you sat there and signed that giant stack of paper, what did you actually create?
Now, this is where it gets really interesting. You probably think your mortgage's promissory note is just a big IOU, right? Well, the argument here is nope. Because it has a maturity date longer than 9 months, it's legally classified as a financial security. And that one little detail is supposed to change everything, putting it under a totally different set of rules, specifically UCC Article 8.
So what? Why does it matter if it's a security? Well, according to this view, if you're the one who actually created that financial asset, then you have some incredibly powerful rights you probably never knew about. The sources point to these specific UCC codes that they say give you the right to make a counterclaim and even hold a property interest in the note as it gets bought and sold.
And all of this leads to a tool called an adverse claim. The theory is, once you understand that your note is a security that you created, you can file this claim. It's basically you raising your hand and saying, hey, that financial asset you're passing around, I have a property interest in it, and it's a violation of my rights for you to be holding it.
Okay, so from mortgages, let's step into the courtroom, because the same logic is being applied here. The sources we looked at say a courtroom isn't a place with automatic authority. It's just another place where you can be tricked into making a contract. Now, this is a central and, yeah, a pretty startling claim. The argument goes that the second you show up and enter a plea, you're essentially agreeing to do business. You're not in a court of justice anymore. You're forming a contract with a private company and giving them power over you. So, how do you avoid making that contract? The proposed strategy is something called a conditional acceptance. You don't say guilty. You don't say not guilty. Instead, it's like saying, sure, I'll accept your offer, but only if you can first prove on the record that you have a valid claim and the authority to bring it against me. See what that does? It shifts the whole burden of proof right back onto them. And the theory pushes this even further. It starts asking whether the courts we're all familiar with even have the right to hear cases about land, like foreclosures, at all. It's argued that this power might actually belong exclusively to very specific land courts, which means the whole case could be happening in the wrong venue. So you might be thinking, okay, if courtrooms are contracts and jurisdictions are tricky, what's left? Well, this brings us to the proposed solution. And it's all about using the system's own tools, specifically its financial and tax forms, to make your case. Get ready, because this one will bend your brain a little.
The theory completely flips the script on what a bill is. It argues a bill is not a demand for you to pay. Instead, it's an accounting slip showing how another company used your credit. And that dollar amount, that's supposedly the tax they owe for using your credit as an asset.
So how do you supposedly settle these accounts? Our source material lays out a very specific three-step process with IRS forms. First, you file a form saying, hey, I'm the one who issued this. Then you file another one reporting its value. And then, and this is the really counterintuitive part, you report that bill's amount as income to you on your taxes. The claim is that this process allows the IRS to zero out the debt and give you a refund. And this whole idea blows up even bigger when you look at the tax system. The claim is that we've got it all wrong. These transactions aren't actually income at all. They should be seen as gifts moving between a donor and a recipient. And if that's true, well, that puts them under a completely different set of rules, gift and estate tax rules, which come with their own credits and exemptions. All right, for our last section, we're going to zoom all the way in down to the tiniest detail, the words themselves. Because the claim here is that the language used in the legal world isn't just confusing on purpose, it's a weapon designed to trick you. Take a word we all think we know, right? A word straight out of every courtroom movie, defense. You hire a lawyer for your defense because you think it means protection, a shield. But the argument here breaks it down. The prefix D often means to remove or the opposite of. So defense could literally mean no fence, no protection. The theory suggests that by asking for a defense, you're actually asking to be left unprotected. And this isn't just a one-off thing. This kind of linguistic breakdown is applied all over the place. Describe is argued to mean no scribe, so not written. A declaration is no contract. And get this, even your name, when it's written with a middle initial, is called a nom de guerre, a war name. It's supposedly a trick to create a fictional entity they can contract with instead of the real you. And this quote just perfectly sums up the whole message from the source material. The idea is that the power to navigate this maze isn't something you have to find out there somewhere. It's like Dorothy's ruby slippers. The remedy has been with you the entire time. You just have to know the rules. And so, that leaves us with a really compelling question, doesn't it? Our sources present a world that seems to be operating by a completely different rulebook. We've laid out their arguments for you, and they claim the solution has been there all along. So the only question left is, do you know the rules of the game?